Welcome to the latest Evershed Sutherland Legal Insights podcast.
Welcome to this podcast, which is part of a series of podcasts on the UK Digital Markets Competition and Consumers Act, or DMCC. The Act received royal assent on the 24th of May of this year. On the same day, the CMA published draft guidance on the digital markets competition regime, and stakeholders have until the 12th of July to provide feedback to this consultation. So far, guidance expected on the consumer aspects of the Act have not yet been published. In terms of timing generally, no precise timing is as yet available on when the Act will be implemented, but it is our understanding that that is still expected to happen before the end of this year. This podcast will provide an overview of the new consumer law financial penalties and enforcement powers available to the CMA under the Act, and what that means for businesses. My name is Julia Woodward-Carlton. I'm a partner in the Competition, Trade and Foreign Investment team at Evershed Sutherland, and I'm delighted to be joined today by my colleagues Matthew Gough, a partner in the consumer team, and Joe Hooper, a senior associate in the consumer team. So let's kick off then, if I can turn to you, Joe, first. What are the key changes that businesses can expect from the Act in relation to financial penalties and enforcement powers?
The key change from the Act's new enforcement powers is that for the first time, the CMA itself will be able to take action against businesses, whereas previously only the courts could determine whether a business was in breach of consumer law. This is an extremely significant change, particularly as the CMA will now be able to impose financial penalties on businesses when exercising its statutory consumer law powers. The new Act effectively applies to any business that interacts with consumers in the UK. Although the UK has had a robust set of consumer protection laws for some time, having redress via the courts only meant that it was difficult in practice for non-compliant businesses to be held to account. Now, under the Act, the CMA will have its own powers to take action for consumers affected by particular breaches and against businesses who are subject to CMA investigations or undertakings. The CMA will be able to issue infringement decisions and impose fines of up to 10% of annual global turnover. As mentioned, this is a significant change to the enforcement regime in the UK, and it gives the CMA a more meaningful set of powers to not only help deal with bad practices, but also to deter businesses from engaging in those infringing practices in the first place.
Thank you, Joe. So, Matthew, turning to you, what action is the CMA able to take against businesses?
Thank you, Julia. The CMA may conduct an investigation under the investigatory powers granted to it under the Consumer Rights Act 2015 if it believes a person has engaged in, is engaging in, or is likely to engage in a commercial practice which infringes consumer protection law or is an accessory to such a practice. The CMA may accept an undertaking from a person in relation to such an infringement, or can issue an infringement notice requiring them to comply with enhanced consumer measures that it considers may be just and reasonable, and under the new DMCC to pay a monetary penalty of up to £300,000, or if higher, 10% of the total value of the global turnover of the business. The imposition of monetary penalties is a true game changer in UK consumer law. Previously, the CMA could seek voluntary undertakings for breaches of certain consumer laws, such as unfair terms. The new powers under the DMCC go much further and will provide the CMA with similar powers as it has when exercising its competition law functions. These powers are similar to those that the ICO has under the UK's data privacy regime and the GDPR. This provides consumer law enforcement with teeth. We have already heard from a substantial amount of UK businesses who are eager to understand the potential impact this may have in the UK in the future. The CMA may also issue an online interface notice requiring a person to remove content from or modify content on an online interface, disable or restrict access to the interface, display a warning to consumers, or delete a fully qualified domain name, and take any steps necessary to facilitate the registration of that domain name by the CMA. If the CMA considers a person has breached an undertaking, it may issue a breach of undertaking notice, setting out requirements to comply with the directions of the CMA, and or to pay a monetary penalty of up to £150,000 or 5% of annual global turnover, whichever is the higher. An additional daily penalty of up to £15,000 or 5% of daily global turnover, whichever is higher, can be placed when non-compliance continues. If the CMA has reasonable grounds to believe a person has provided false or misleading information to the CMA, it may issue a false information enforcement notice to that person, imposing a monetary penalty of up to £30,000, or if higher, 1% of turnover. The Secretary of State may, by regulation, amend the amounts of the monetary penalties under the Act, or amend the list of what constitutes a breach of consumer protection law, and for which the CMA can exercise its direct enforcement powers. The CMA is due to issue rules and guidance regarding the exercise of its powers under the DMCC Act. We're waiting for those to be issued.
Thank you, Matthew. Well, it certainly sounds like a real game changer, and as you said, brings it much more into line with powers that I'm familiar with from the competition arena. So, Joe, building on that, what can the CMA actually do if a business doesn't comply with a notice that the CMA serves?
Where a person fails to comply with a notice that's given by the CMA may issue a breach of directions enforcement notice, which sets out variations or revocations of the original enforcement direction, or requirements to comply with directions of the CMA, or to pay a monetary penalty of up to £150,000 or 5% of annual global turnover, whichever is higher, and also an additional daily penalty of up to £15,000 or 5% of daily global turnover, whichever is higher, while that non-compliance continues.
And Matthew, are there any criminal offences being brought in under the DMCC Act?
Well, thank you, Julia. That's a good question. Yes, the DMCC absorbs and expands on the existing provisions of the Consumer Protection from Unfair Trading Regulations 2008, which is the framework that prohibits the use of certain unfair commercial practices by businesses. And this was brought in following European directives at the time. The Act also includes fake reviews and drip pricing in the list of banned practices, better reflecting that more and more of us are contracting with businesses online. There's greater flexibility for the Secretary of State to make further changes to this list of prohibitions. Failure to comply with a prohibition on the use of certain unfair commercial practices remains a criminal offence, which could result in the imposition of a fine or imprisonment for up to 2 years. The Act also provides it is an offence to enter into an off-premises subscription contract with a consumer and not give the consumer information about its initial cooling off rights in accordance with the requirements set out in the Act. This is very much a new offence, and a fine may be imposed as a penalty.
Thank you, Matthew. So with all of that coming down the track, Joe, what would your advice be to businesses as to how they should start preparing for the implementation of these powers?
So there are a number of things that businesses can do at this stage. The new arsenal of enforcement powers given to the CMA will mean that consumer law compliance will need to sit high on the agenda for businesses who interact with consumers in the UK. So, for example, a business that is not resident in the UK but has an online presence in the UK and reaches out to consumers will need to ensure compliance. These powers are similar to the consumer law powers available to numerous regulators in the EU. Businesses will need to assess their processes, website content, customer communications, and other customer-facing materials to ensure that they are all compliant with the consumer law requirements that are already in place, as well as identifying how the Act's specific changes around banned practices and subscription rules might affect them. Businesses should review internal policies regarding legal risk decision-making, escalation, and login of consumer law compliance and breaches, and consider developing and delivering internal consumer law compliance training throughout the business. So this could include training to teams such as marketing, customer complaints, legal, or compliance. As you mentioned at the outset, following royal assent on the 24th of May 2024, the CMA launched a consultation on their draft digital markets competition guidance. We recommend that businesses respond to this and also to any other consultations that the CMA issues, as we expect to receive more practical guidance from the CMA on its approach to enforcement of consumer laws more generally in this guidance.
Well, that brings us to the end of this podcast, and thank you, Matthew and Jo, and to all of you for listening. Please do look out for future podcasts in this series, which we will continue to release on different topics. And these will include any further information on the timing of implementation and on any further guidance issued. Thank you.
Thank you for listening to the Evershed Sutherland Legal Insights podcast.